Dear student, hope all of you are good. So we will discuss element of crime. So this is the topic of criminal law 1. This is our first topic of criminal law 1. So before we start this topic, we should know what is law, because we are talking about the criminal law. At first we will discuss what is law, then we will discuss what is crime, then we will discuss element of crime. So if we see the definition of law, many jurists, many experts explain differently. But the very easiest definition, I think, according to the Oxford English Dictionary, law is defined as the body enacted or customary rules recognized by the community as binding. Okay, law is some rules and regulations that is recognized by the community and it is binding to the community. Who is the community? We are the community. So we recognize some rules and regulation. Okay, we impose some rules by parliament. The parliament member, they are representing us, so they are making some rules for the community and which is binding for us. That is law. Okay. Sir John Salmond, in his book, he mentioned, he defined the law, and some others, John Austin, he also defined. You can read it. Another one is the easiest and acceptable one I like. According to the Blackstone, he mentioned law is a rule of action prescribed or dictated by a superior who is an inferior in bound to obey. This is also a good definition of law. So basically the summary is, the conclusion is, law is a rules recognized by the community, recognized by the parliament, and which is binding for us. Yeah. So there are two type of laws: public law and private law. Yeah, public law and private law. Public law means a criminal law, and the public law is basically the law which govern the relationship between the individual and the state. Okay, public law means the relationship between individual and state. The public law may be further defined into two categories. Okay, constitutional law and criminal law. So criminal law is one of the laws, example of public law. So when we will commit any crime under the criminal law, so we have to deal with the state, because the public law is the relationship between the individual and the state. But if you see the private law is concerned with the matter that affect the rights and duties of the individual among themselves. Basically, private law is known as civil law. So if any, for example, contract law, trust and tort. Okay, if any dispute arise between us for the private law, so a state will not interfere here. It's the relation between individual, between you and me, between Rahim and Karim. So here, if any dispute arise among us, then the state will not interfere. We have to face each other. So it is private law. But we will talk about the criminal law. So criminal law is public law. So if we commit any crime, then we have to deal with the state, because the public law or criminal law is a relationship between the state and the individual. Yeah, is the criminal law. Criminal law is a law codified the various offense committed by individual against the state. So under criminal law, if you or if I commit any crime, it will consider that I'm committing this crime against a state. For example, if I kill someone, or if I rape someone, or if I injure someone, then if the victim go to the police station and file a case against me, then police will arrest me, and the public prosecutor will bring the allegation against me. The public prosecutor, on behalf of the state, he will bring the allegation against me. He will represent the state in the court. So if I commit any crime under penal code or under criminal law, then I have to fight against the state. It will consider that I am committing crime against the state. The criminal law imposes an individual the obligation not to commit crime. A crime is wrong against the state for which punishment is inflicted by the state, the proceeding being brought by the public prosecutor. The essential element of public prosecutor. Okay. So this is the thing. Now we'll talk about the crime. So if you commit any crime under criminal law, it will consider that we are committing crime against the state. So now what is the crime? Crime is an offense, wrongful act that is punishable by law. Okay, an action or omission which constitute an offense and is punishable by law. What is crime? So crime is something, an offense, wrongful act, and is punishable by law. So taking cannabis or carrying cannabis, Malaysia is called ganja. So taking cannabis or ganja is an offense in Malaysia, but because it is prohibited by Malaysian law, so it is a crime. It is a crime in Malaysia. So if you go Brazil, some countries, Western countries, taking cannabis is not a crime because it is not an offense under their law. So it is not punishable by their law. So it is not a crime in their country. So crime is different. Is very it's different here and there. So something is crime in Malaysia, maybe the same thing is not crime in other countries. For example, another example, abortion. Abortion is a crime in Malaysia, in Bangladesh, Pakistan, some countries. But if you go some countries, Argentina, here and there, okay, abortion is not a crime because that is not punishable by law. Okay, so crime is an offense, wrongful act that is punishable by law. So you have to find that if something punishable by law, that is crime. So if it is not, if something not punishable by law, that is not crime. So here also some expert they mention, according to Blackstone, crime is a violation of public rights and duties due to the whole community. To define crime is a violation of public rights and duties due to the community. Okay, another few definition I mentioned here. You can see here all of these things, all of the definition. We don't have enough time to discuss all because we will make a short video. We will explain all the things in our main class. The difference, if we discuss the difference of criminal law and civil law. Criminal law means public law, civil law means the private law. Okay, so criminal law means public law. So if public law, that means the relation between individual and the state, and private law, the relation between individual and individual. So if we see the definition or difference between these two, the offense is against the state. When you will commit any crime under the criminal law, then it will consider that you are committing offense against the state. But in private law or civil law, if you commit any crime against someone, it will consider that the wrong are between individual. The proceedings are initiated by the state public prosecutor, that just I mentioned earlier. So if you commit any crime, the allegation will bring to the court. The public prosecutor will bring the allegation against you in the court. The proceedings are initiated by the individual. So if you commit any crime against someone else under the private law, then the individual will appoint their private lawyer. The lawyer will bring the allegation against you. Public prosecutor will not interfere here. Proceeding can be withdrawn. Criminal law proceeding can be withdrawn. For example, cannot be settled outside the court except with the approval of the Attorney General by virtue of Article 145 of the Federal Constitution. So if you commit any criminal crime, if you commit any crime under criminal law, then if you want to withdraw the proceedings from the court, you have to take permission from the Attorney General. Okay, and under the private law, I mean civil law, proceedings may be discontinued and can be settled outside the court. Criminal law, burden of proof lies on public prosecutor and generally doesn't shift to the accused. So burden of proof in criminal law, burden of proof normally lies on the public prosecutor. But there is some exception. We will discuss it later when we will discuss the defense. Okay, in civil law, the burden of proof lies on the plaintiff. It may shift to the defendant. The defendant the burden of proof is beyond reasonable doubt. So burden of proof is beyond reasonable doubt. So burden of proof, you have to prove beyond reasonable doubt in criminal law. In civil law, burden of proof is on the balance of probability. So burden of proof on the balance of probability. Legal consequences under the criminal law are more severe. Than that under the civil law. Okay, legal consequences under the criminal law are more severe than that under the civil law. For example, death sentence, life imprisonment, whipping, and fine. Legal consequences under the civil law are less severe than criminal law. For example, mandatory compensation, injunction, specific performance, self-help. For the private law, there is no life imprisonment, there is no death penalty. Okay, so it is less severe. Criminal law, the term of terminology used, prosecute, here versus read as against. So public prosecutor against accused versus accused. And here the civil law, the term of terminology used, sue versus read as and, public plaintiff and defendant. If the public prosecutor succeed, the accused will be convicted and the word guilty is used. The result is judgment for the plaintiff or the defendant. The word liable is used. Here the word liable is used and here the word guilty is used. For the crime, there is an element, there is a maxim, very important maxim. It's very basic and important maxim that you have to remember. Actus non facit ream nisi mensit rea. That means an act does not mean a person legally guilty unless his mind is legally blameworthy. Unless his mind is legally guilty. So if the mind is not guilty, if the mind is not blameworthy, so there is no wrong. There is no crime. This is the basic general maxim. So the general rule is, so if the mind is not guilty, so there is no crime. Accordingly, there are two ingredients for the crime, actus rea and mens rea. So what is actus rea? Actus rea, very easy to understand, physical activities. Okay, if you punch someone, if you shoot someone, kick someone, okay, shout someone, shout at someone, okay, just bodily, and if you do anything that is visible, okay, is body activities, the conduct or action of the accused which produce or constitute the forbidden harm. For instance, firing the gun and killing the victim. So hope you understand the actus rea. Okay, actus rea, the conduct or action of the accused which produce or constitute the forbidden harm. For instance, firing the gun, killing the victim. So if you shoot someone, that means you use your hand, physical activities. Okay, kick someone, shout someone. Okay, then it's called actus rea. Mens rea, a blameworthy state of mind. For instance, intending to kill when firing the someone. Mens rea means guilty mind. What was in your mind? If you had guilty mind and if you had actus rea, then it is crime. So if anyone bring any allegation against you that you committed a crime, so he have to prove that you have actus rea and mens rea. Actus rea is very easy to understand or very easy to prove. Okay, you shoot someone, there is some video, maybe CCTV footage, you kick someone, maybe someone saw. But mens rea, guilty mind, how you will prove? It's very difficult to prove. Okay, I don't know what is in your mind. Okay, it's easy to prove. The element of mens rea is pre-planned. As a public prosecutor, if you can prove that the accused had pre-planned to commit this offense, that means the mens rea will prove. For pre-planned, how is pre-planned? I shoot someone. Okay, before I shoot, I went to buy a gun and I came to kill him. Okay, I came several times. Okay, I visit that place. Okay, I waited for the suitable time. Okay, if the public prosecutor can prove that you had pre-planned to commit this crime, okay, mens rea will be proved easily. Yeah, in the same time, you have to prove mens rea with the circumstantial evidence, eyewitness, and with other evidence. So, as a lawyer, you have to be very clever how you will prove mens rea. Okay, the provision of penal code, all the provision of penal code didn't mention about the mens rea. But you have to prove mens rea. If you want to prove someone committed crime, you have to prove mens rea and actus rea. But some section very clearly they mention about the existence of mens rea. For example, I can show you. Mens rea, for example, section, yeah. Section 142, intentionally join unlawful assembly. Intentionally, when you will prove that someone attend the unlawful assembly intentionally, that means mens rea is there. Sale of drug, who is known to be adulterate, then cause the death of any person by doing any rash or negligence act, then intending to take dishonestly any movable property. Intending to take dishonestly any immovable property. So in this section they mention clearly that you have to prove mens rea. Okay, so at some section they didn't explain or mention about the mens rea very clearly, but you have to prove the mens rea. So the two element is very important for the crime: actus rea and mens rea. Actus rea is physical activities, okay, punching someone, kicking someone, shooting someone, okay, visible thing, okay. People can see, people can recognize, okay, you shoot someone, you kick someone, yeah. Then mens rea is guilty mind, okay, that you can prove. The requirement of mens rea is the pre-plan. So if you can prove that someone had pre-planned to do some offense, then mens rea will be proved. But as a lawyer, you have to prove it very carefully. You have to be very smart to prove mens rea. Maybe you can prove with circumstantial evidence, okay, eyewitness and other evidence. You can prove the mens rea. Okay, so I hope all of you are clear about the elements of crime. I just try to give you the basic of mens rea and actus rea. If you don't understand the mens rea, what is mens rea, what is actus rea, then you will not understand the whole criminal law. So in our class we will explain mens rea and actus rea with the case reference. Okay, we will discuss the cases and we will explain it nicely. So if you have any question to understand, If you don't understand anything about mens rea, actus rea, don't forget to ask me next class. Okay. So, thank you.
বলেছি যে আমার মাথাটা তুলে রাখো, তুলে রাখলে কি
Maybe you can prove with circumstantial evidence, okay, eyewitness and other evidence. You can prove the mens rea. Okay, so I hope you all of you are clear about the elements of crime. I just try to give you the basic of mens rea and actus rea. If you don't understand the mens rea, what is mens rea, what is actus rea, then you will not understand the whole criminal law. So in our class, we will explain mens rea and actus rea with the case reference. Okay, we will discuss the cases and we will explain it nicely. So if you have any question to understand, if you don't understand anything about mens rea, actus rea, don't forget to ask me next class. Okay. So, thank you.